Mr. Solers or Miss Darrow, are you there? Then
All right.
Mr. Becker, are you there?
Hey, Jerry, I need to get in here.
Hi, Nick.
Hey.
Back from under. They're trying to talk.
Is Rich Solers there?
I just got on.
Perfect, Rich. Thanks.
Jim, this is Ryan.
Hi, Ryan.
Hey.
Let's go. Jody, Darrow, are you there?
This is Rick Solers again. Jody's not going to be able to make it.
Okay.
Are we going to mute somehow our end so we can just listen but not be heard?
You'll have to mute your own phones if you have that ability.
I may, but I certainly don't know how.
Hang on one second.
Environmental Quality Council, Jim.
Who is it that just came on?
Good. Sam, can I
Yeah,
give you a
Bruce
call
Levin.
back in about half hour?
Bruce Levin?
All right, thanks, man. Bye.
I believe
Bruce?
Bruce Levin just came.
Bruce, Mr. Levin? Thank you. Is Andrew Fay on?
This is Rick Solers. Andy's with me.
Okay. See. Is Amy Hansen going to be on, Mr. McFarland?
No, she's not.
Okay.
That's Richard.
Mr. Ruby,
Yes.
this is Mr. Good. Am I on the right conference call?
You are. Yeah, we're just what we're going to be doing is we have two cases we're going to be deliberating, Mr. Good. One will be yours, but it'll be after this one. The first one they'll be deliberating is the Hopper matter. And then as soon as they're done with the Hopper matter, they'll take up yours.
I'll just sit there and shut the hell up.
Yep.
Okay, thanks.
I think that's everyone. Mr. Beck, is Travis Becker on, or is he going to be present?
This is Rick Solers again. I don't believe so. I think they were going to be represented by Jody Darrow, and then she asked, but just indicated she couldn't make it, so I don't believe so.
Okay, thank you. Miss Lally, or Chairman Lally, it's all yours. I think everybody's here.
Okay, I call this meeting of the Environmental Quality Council to order. Present from the council is by phone, Nick Agopian, Tim Splitner, Rich Fairservice, Deb Balmer, Dr. Dave Bagley, and myself. Present from the council is I'm sorry.
Hang on.
And
Hang on. Rich,
Yes.
your phone's doing weird things.
Let me mute it then.
Okay.
Hold on.
I think you're good to go, Chairman Lally.
okay. Present representing the council is Jim Ruby, executive assistant, and Joe Girardin, paralegal, and also Ryan Shalehouse from the Attorney General's office. I will turn this over to Hearing Officer Bagley. I'm sorry, Hearing Officer Bagley for the first hearing.
Thank you, Chair Lilly. I'm Dr. Dave Bagley. I'm the hearing officer in docket 17-5801. I would like to take care of a couple procedural matters at this time. First, since this is by teleconference and it is being transcribed by a court reporter, please don't say anything without identifying yourself first. Second, this is the deliberations of the council, so if you are not a council member, please do not say anything unless you are specifically asked a question by the council. With that, I would like to confirm who is on the call. I think we know, but I'd like to confirm it, and also for the court reporter. So I'm going to ask by name whether you're there, and if you aren't there, let's say no. If you are there, say yes. So we'll start. Tim Flitner.
Yeah, here.
Rich Fairservice.
Yes, here.
Thank you, Rich. Megan Lawley.
Yes.
Megan Lawley, did you hear me? I know you're there, but did we lose Megan?
She's there.
Okay.
Sorry, forgot to unmute it.
Oh, okay. Thank you. Deb Balmer.
Here.
Nick Agopian.
Here.
Pat Troxel.
Here.
James LaRock.
Here.
Scott McFarland.
Here.
Mike Dimmick.
Here.
Bruce Levin. Rich Sollers.
Yeah.
Andrew Fay.
Here.
Thank you. Is there anyone else on the phone specifically for the hopper disposal case? And if you're on the phone for the good case, that's coming. We've got to do this first though, and I don't need to know if you're on for the good case, but anyone else on specifically for the hopper disposal case?
Yeah, this is Bob Doctor with the Field and Tap.
Thank you. Anybody else? Great, thank you. Not all council members were present for the final hearing in this matter. So for the record, I will ask those of you who are not present whether you have had the opportunity to review the evidence and the transcript in this matter, and if you are ready to make a decision. Mr. Fairservice.
Yes.
Mr. Agopian.
Yes.
Ms. Balmer.
Yes.
Thank you all. There being a quorum present, I will now close the hearing in this matter. So now, as a reminder, the burden of proof is on the petitioners, Fremont County Solid Waste District, Fremont County, Mr. Scott McFarland, and Wyoming Waste Systems to prove by a preponderance of the evidence that the permit as proposed by DEQ should not be issued. Now, what I'd like to do is I will ask for a motion and then a second for the motion. And then after that, I will go through each of the council members and ask each of you for your comments, your deliberation, and you'll get a chance. I'll even go through the twice because since we're on the phone, I can't see if you're begging to ask another question or comment. So everyone will get 2 cracks at this. So with that understanding, I would like to ask for a motion to approve the permit for hopper disposal with a condition requiring an immediate bond review to allow the Department of Environmental Quality to correct the erroneous financial assurance estimate. Do I have a motion for that?
This is Megan, so move.
Thank you. Second?
This is Deb, I'll second.
Thank you. So it's been moved and seconded. I'd now like to go through each council member, and I'll ask you for any comments. Chair Lawley, do you have any comments?
Not at this time.
Thank you. Councilmember Balmer.
I don't at this time either, Dr. Bagley, thank you.
Thank you. Councilmember Agopian.
I don't have any either.
Thank you. Councilmember Fairservice.
No comments.
Councilmember Flitner.
I hate to be the only one that says anything about this now. I'm getting a little gun shy, but I'm trying to figure out whether it's that nobody has anything to say or nobody remembers it. Yeah, I just have a couple quick comments. I think it's important to note that what the protesters were asking us to do basically on this permit was to judge the disposal waste permit on a couple of transgressions that happened in the past, and basically take that and say, well, because there's a potential for him to do something he shouldn't in the future, we should deny this permit. So I'm not big on judging somebody down for things that he has not done yet. That is a DEQ enforcement action. That is not our responsibility to make a judgment on the future. You know, the DEQ moves in enforcement after those things happen, and I am fully confident that they will do so if there are any transgressions. So that one should be put to rest pretty easily, and especially when you consider one of the NOVs was pouring that concrete while the permit is pending, which I realize that's what the statute says, but I'm not going so far as to say that should be held against him. That's a person's private property. I think that's a fundamental overreach by the DEQ that should be changed. And for issuing that NOV, I don't think they had any choice. But as far as punishment for that NOV, I think that doesn't play well. I think furthermore, we ought to be encouraging people to try to do something with all the garbage we have these days. So I'm inclined to let this petition go through. So that's all I have.
Thank you, Councilmember Flitner. I also have some comments, so you won't be alone, Tim. I have some thoughts. This was an interesting case. The low hazard, low volume process for permitting is very straightforward, and it's pretty simple. The question that I felt we had to answer was that process followed appropriately? You know, and before I provide my comments on that, I want to mention, you know, is there a potential for this facility to violate its permit? And I think the answer to that is yes, but there's a potential for any facility that has a permit to do anything to violate that. And so as Mr. Flitner said, we have the enforcement side to deal with that. Now, the council can weigh the probability that there will be a violation, but to fully determine or estimate a risk, we'd also have to weigh the consequences. The statute has basically determined that the consequences are small. Otherwise, there would be a more complicated permit process. And so while the probability of a violation may occur, the consequences are by statute determined to be small. And in any case, those consequences were not brought forward as evidence in the hearing. So the council really can have no opinion on that. And really, boils down to, was the appropriate legal process followed in this case? So to me, the answer then is yes, the appropriate legal process was followed, but the permit application did include errors. The key error was the financial assurance estimate. All parties have agreed that the estimate was incorrect. And so I will plan to vote for the motion to that the permit be granted with the condition that immediate bond review occurs so that we can get the correct financial assurance estimate and the correct bond in place. So that's all of my comments. So now I'll go back through and maybe folks will, you have another opportunity to add any comments before we do the vote. Chair Lawley, any comments?
No, I think you both covered it pretty well. Thank you.
Thank you. Councilmember Balmer?
No, only to say that I believe the objections raised by the parties did not justify denying the permit application as well. So I intend to vote in favor as well. Thank you, Dr. Bagley.
Thank you. Councilmember Agopian?
Well said, Mr. Hearing Officer.
Thank you. Councilmember Fairservice?
No comment.
Thank you. Councilmember Flitner, anything to add?
Just one question. Wasn't there an issue on one of the maps or something that the DEQ said was, commonly used, but it didn't quite measure up to what the statute said? Do we need to correct that in an amendment in this permit as well? Wasn't that part of what we discussed there that day?
Yes, this is Dave Bagley. Mr. Flitner, we did in fact discuss that. And if that was something the council would like to add, we could amend the motion to add that. Specifically, the permit application requests that maps be USGS maps. A Google map was submitted. The evidence presented, the testimony presented was that the DEQ wants to use maps they feel are the best for the situation, and that Google Maps and other non-USGS maps perhaps have been used in the past as well. So it may be that the DEQ should change its form so they don't ask for a USGS map, but if you'd like a USGS map to be included, Tim, then we would you'd want to make an amendment to that effect.
I really don't. I think it's fine if we use it. I just don't want there to be any danger, and maybe Ryan could speak to this, that this could hang up on an appeal because of that, because we did in fact discuss it, and that is in fact what the statute says. If we're on good legal ground, I'm perfectly in favor of streamlining this process in the future. So I'm good either way.
All right. Thank you, Tim. Mr. Shellhouse, any thought on that, or that you could say in open session? I don't know if we need to go to executive session for that.
Yeah, this is Ryan. I think you spelled it out good, Dr. Bagley, on if the council were to want to make that, I guess, a condition as part of the permit to have the applicant attach a USGS map, you could do that. But I would leave that up to the council.
Oh, thank you. Thank you. All right, then. I have no further comments, so I will ask council members if someone would like to make an amendment to that effect to add the requirement of a USGS map. If I don't hear an amendment, I will assume nobody wants it. All right, hearing no amendment, we are ready to vote on the motion. So I will take a roll call vote. Just as a reminder, the motion is to approve the permit for hopper disposal with the condition requiring an immediate bond review to allow the department to correct the erroneous financial assurance estimate. Chair Lawley.
I vote in favor.
Thank you. Councilmember Balmer.
Aye.
Thank you. Councilmember Agopian.
Aye.
Thank you. Councilmember Fairservice.
Aye.
Thank you. Councilmember Flitner.
Aye.
Thank you. I vote aye as well. So the motion has been passed. The statutes require the order in this matter to be finalized within 30 days of the close of the hearing, which was today. The 30th day is January 14th, 2018. That is a Sunday. The 31st day is Monday, January 15th. That is Martin Luther King Day, which is a holiday. So we will have this order prepared by finalized by Tuesday, January 16th. I'd like Mr. Shellhouse, if you would please prepare the order and send it to the council by no later than January 8th, 2018. Council members, please review the order as soon as you get it, as soon as possible, and let us know, Mr. Ruby, myself, Mr. Shellhouse, know of any concerns or changes you believe need to be made. And then we will hold presumably a very brief teleconference on January 16th, tentatively scheduled for 2 p.m. And we will finalize that shortly as well, but tentatively, hopefully a brief teleconference on that day to vote on the order itself. That is all I have. And I will turn it, the hearing or the meeting back to you, Chair Lawley.
Thank you, Dr. Bagley. I will now turn the hearing, or the gavel back over to Councilman Balmer to complete the good hearing. Thank you.
All right, thank you, Chair Lally. This is Deb Balmer, and I'm the hearing officer in docket 17-4201A. So I would just like to reiterate procedurally that this is by teleconference, and we do have a court reporter present. And so everyone will need to identify themselves before they speak. And because we're in deliberations of the council, only the council members are going to be discussing this case. And so I would just ask that anyone else that's present do not speak unless you're called upon. So let's go ahead and do a real quick roll call so that we know who is here. Mr. Flitner.
Yes.
Mr. Fairservice.
Yes.
And Chair Lally.
Yes.
Dr. Bagley.
Here.
Okay, and Mr. Gopian.
Madam Hearing Officer, I recuse myself from this matter.
Okay, thank you, Mr. Gopian.
Listening in as a citizen at this point.
Alrighty. Mr. Coleman.
I'm here, Madam Hearing Officer.
Andrew.
I'm here, Madam Hearing Officer.
Okay, thank you. Mr. Good.
Yes, ma'am, I'm here.
And Mrs. Good. Yes. All right, great. Is there anyone else on the phone specifically for this case and this is the good case, docket number 17-4201A. Anyone else present? I'm hearing some feedback on my phone. I don't know if everybody else is hearing that as well.
I think it's.
Yes, kids in the background.
Kids in the background, yes.
I think it's Mr. Good, but I don't.
Mr. Good,
Okay, also present,
It could be
hello?
Good or Megan.
Mr. Good, is that your phone that's having the kids running around?
No, it's not ours.
Okay. Chairman Lally, is it yours?
No, I've got mine on mute.
All right. Anybody know who has kids running around making noise? They're not here. Nope, they seem to have gone away, so.
Nobody's going to admit it, Jim. Also present are Jim Ruby, the Executive Director of the EQC, Joe Jordan, the Legal Assistant, and Ryan Shellhouse, who is the council's legal counsel. All right, we do have one preliminary matter. Let's see. Mr. Good filed a motion for the recusal of Councilmember Agopian. Mr. Agopian has recused himself from this case, so that motion is moot at this time. And not all council members were present for the final hearing in this matter. So for the record, I'm going to ask those of you who were not present for the entire hearing whether you've had an opportunity to review the evidence and or the transcript or the YouTube video in this matter, and if you're ready to make a decision. Mr. Fairservice.
Yes.
And Dr. Bagley.
Yes.
Okay, great. All right, in this case, the burden of proof is on the DEQ, and the issue before us is whether the notice of violation of the act for failure to provide the required reclamation performance bond should be affirmed. We'll use the same procedure as Dr. Bagley just used in the prior deliberations. So at this time, I would accept a motion to approve the NOB in order as proposed by the DEQ. Do I have a motion?
So moved.
And who was that?
Dave Bagley.
Okay, thank you. Do I have a second?
Rich, second.
Okay, great. Thank you. All right. At this time, let's go through and see if anyone has any comments they would like to make before we take a final roll call vote. So I will start with you, Chair Lally. Do you have any comments on this case?
Well, I'm sympathetic with Mr. Good. I have some real issues with the lack of bond for years, and that's really what troubles me about this whole case. Thanks.
All right, thank you. Councilmember Bagley.
Thank you, Hearing Officer Balmer. Yeah, as I watched through the YouTube and followed along, and actually was able to get the additional exhibits that were brought up. I think it was DEQ 10, 11, and 12 as I went through this. And this case is, it's interesting. I guess my first concern was there was plenty of opportunity for Mr. Good to provide comment along the way. There was the inspection report in January where DEQ provided an estimate of the bond. There was an opportunity then, but yet no evidence was presented that besides testimony that Mr. Good spoke with people, and that's fine, but there was no an email saying, no, I disagree with this. And then the director's bond notice in March. And again, saying this is how much bond the DEQ feels you owe. And there was no email, no letter saying, I disagree with this. I think the bond should be this, or even a letter saying, I disagree, let's sit down and meet. But some kind of additional evidence besides the testimony. I like to see documents that show, oh, okay, yes, you did in fact mention that. And then finally the NOV was, an order was announced, and at that point there was an appeal, which is of course fine, but now there's no backup evidence to say, yeah, I've had a problem with this ever since I got that report, that inspection report in January. So, you know, the question of how much bond there should be is one I don't want to get into, because I saw 3 different estimates in the evidence presented. I saw the DEQ's number, and then I saw 2 additional numbers provided by Mr. Good. And well, at this point, it doesn't matter to me which is the right number. The issue is there's really no evidence of a concern. So I'm very I personally think that the notice of violation was appropriate, and we'll be voting to uphold that. I have a issue with the order, though. The order says pay the bond amount. That is, pay the extra bond amount. And yet evidence was presented that there has been no additional mining since 2011. And so my question is, Mr. Good has not paid an additional bond amount since an agreement, I think it was 2012, 2013. So I don't know that is taking us anywhere. There's no mining going on. I would suggest, and I'll throw this out for council members to think about, but I am considering an amendment to change the order to say that if there actually is a permit in place, and I'm not sure that there is, but if there's actually a permit in place, that we simply revoke the permit, and away we go. That's where I'm at on this. Thank you, Ms. Balmer.
All right, thank you, Dr. Bagley. Councilmember Fairservice, any comments?
None at this time.
And Councilmember Flitner.
Yeah, I've got a few here. To me, this boils down to 3 different things, and Dr. Bagley touched on one already when he questioned the validity of the permit. I'm not sure how you can transfer or give a permit when you have a list of things in your own stipulation that need to be met that aren't met. One being the BLM easement, and the other being, of course, the bond itself. So, you know, it makes me wonder a little bit, since I'm one of the 2 people on this council that know the history going back to 2011, that the permit wasn't issued as a point of leverage to get some bonding in place. And that's kind of putting the cart ahead of the horse. And the second problem is, I think it's just when your best defense is, well, we want to use 2016 data because we don't, it better stands behind our case. If you're the DEQ or Mr. Coleman, and that's what you're saying, that is a weak way to present a case for the state of Wyoming. They should have been working this out with more current data if it was available to them. I'm really not in the mood to reward the DEQ for holding on to a bad position just so they can win. That I find just a little bit offensive. I think they should have taken that consideration and that data into consideration, and maybe at least made an attempt. Now, I'm not saying Mr. Good was all in the right here. He missed those deadlines, and there is absolutely no argument that he had plenty of time to ask about those and to oppose them. But was he the first person to make a mistake or the second? And you know, when you're going to issue an NOV, you need to be right on all of it. And that brings me to my third point is there are obviously errors in the DEQ's data. Now, Ryan, you stop me if I get myself in trouble here. But I went out to that mine when I got home to see if they looked like the maps say they look like. And I'll suffice it to say that I think Mr. Good makes a good point. Some of those measurements are off. Now, I couldn't measure sizes of piles, but I can step off head walls and things like that. The other thing that's another complete red flag to me was the 15 inches of topsoil that has a large part to do with the bond itself. That country, most of it won't have 4 inches of topsoil in it. And if I understand the DEQ's regulations, the point is to put it back in its natural condition. So adding 10 inches of topsoil or 9 or 8, that's a little beyond the call of duty, I would think. So that kind of hit me as a red flag a little bit. And again, when you're going to issue an NOV, you kind of need to have your facts right. You know, to say nothing of the fact that they're using an obviously biased map from one of his competitors who, as I recall, leaned heavily on just about everybody involved in 2012. So that makes me nervous. So there's also the fact that, you know, when I first got on this council, I was most impressed with the DEQ and their ability to work with and help people. I'm seeing none of that here. I know there's a personality conflict, and that's just happens sometimes. But again, they're being paid by the taxpayer to avoid this, and I don't appreciate spending the state's money on a hearing when again Andrew Coleman's best defense is we're going to use 2016 data. Those are state monies, and that is a terrible, terrible defense to take us all to a hearing without any attempt to use more current, more accurate data in the hopes that maybe this could have been settled. So as I see it, you got two people at fault here, both the DEQ and Mr. Good, and I'd say they're about meeting in the middle. So it doesn't make any sense to me to punish one and pat the other one on the back. So I'm, as you can tell by now, I'm completely against any kind of an NOV for all those reasons, but mainly because they never should have transferred this permit. I still believe they did that to get out of the fire of that bond issue that's 20 years old. It was under bonded in 2012 when we talked about it. It's still under bonded. And so that's a way to get out of that. But that's not the reason to issue an NOV. Now, if he was out there mining and that bond wasn't in place, I'd be the first one to go for an NOV. But there's kind of no harm, no foul out there right now. And this was overstepping. So sorry to take so long, but that I feel pretty strongly about that.
All right, thank you, Councilmember Flitner. Well, in my review of this case, I'm bothered by the fact that it's been hanging out there for 5 years. DEQ has been trying to obtain the bond for 5 years. I agree with DEQ that finality is important in bonding decisions because, you know, this particular action from activities from 2016, not 2017, and that's the information and the data that the DEQ was using. And so I was a bit bothered by the fact that Mr. Good he's overbonded in another place, you know, right there at the same location, basically. And it's something that he was hoping could be worked out with DEQ so that rolling one bond over from the other would take care of this. That hasn't happened. That said, I don't think that issue is necessarily ours to act upon or to make. And, you know, Dr. Bagley, your comment about revoking the permit, I'm not sure that we have the authority to do that. I think council needs to find whether a violation has occurred. We can affirm it or modify the violation, but revoking a permit, I think we would need to maybe go into executive session and discuss with our attorney if we're going to have a motion that has that language in it. And those are just my thoughts. My final thought is that I don't think we should go outside of the evidence that was presented to us at hearing. And that includes, Tim, you going out to the site and trying to figure this thing out yourself. That evidence wasn't presented to us. We need to
Actually,
make this decision. Well,
I only looked, we specifically discussed the head wall. That's really the only thing I looked at was the discrepancy of that head wall. And all I said was there's room to doubt it. I didn't give any numbers or any data. Didn't talk about anything we talked about out there. So basically all I did was look at it from on my feet instead of a map. And we've done that in the past.
all right, I'm just going to disagree that we should use that evidence, because it wasn't, your going out there on the foot wasn't presented to us at hearing. We're supposed to just use evidence that's presented at the hearing, and that's what I'm going to do. And Ryan, maybe you can speak to that.
Yeah. This is Ryan. The hearing officer is correct. The board must only consider the evidence and the testimony presented during the hearing and not do any independent investigation, but make their decision based solely on the evidence and the exhibits and the testimony presented during the hearing.
I stand corrected.
All right, I'm going to go through all the council members one more time to see if we have any additional comments before we have a motion and vote. Chair Lally.
I have nothing.
Okay. Councilmember Bagley.
Yes. So I guess I still agree that based on the evidence that we saw and was presented, there was a violation, and I still support the notice of violation. The order to get Mr. Good to pay seems like it won't. I don't see how that would work because he hasn't paid for 5 years. And I just am not convinced that there is a permit out there because he never paid the order the first time from the settlement agreement. But you know, I'm looking at the law right now, 3511-112, section C says, subject to any applicable state or federal law and subject to the right of appeal, the council may, part 2, order that any permit, license, certification, or variance be granted, denied, suspended, revoked, or modified. So I think from a legal standpoint, we are able to basically say, you know, as a penalty for this notice of violation, and recognizing that Mr. Good hasn't been mining anyway, I think we could revoke the permit, but I won't make that motion at this time, or that amendment.
Okay, thank you, Dr. Bagley. And Ryan, maybe you can help me here. I was under 3511-701C3. And so, Ryan, maybe you can direct us to the correct section that we're supposed to decide this case under. And that one says, if after hearing held pursuant to this section, the council finds that a violation has occurred, it shall affirm or modify such order previously issued, or issue an appropriate order or orders for the prevention, abatement, or control of the violation involved. or for the taking of other corrective action. And even under that section, I mean, maybe we do have the authority to revoke a permit, but which section are we falling under, Ryan?
This is Ryan with the Attorney General's office. It's, you know, I don't want to get too far into the weeds on this, but it was my understanding that I believe the NOV and order were issued pursuant to the 35-11-701 C, at least that's my understanding. But there is other, you know, statutes out there that talk about council authority. So if the council want to go kind of deeper down more into the weeds, I would certainly entertain a motion or be available for executive session. But it was my understanding that the NOV and order, I believe, was issued under 35-11-701 T.
Madam Hearing Officer, this is Tim.
Yeah. Yeah.
I'm jumping to conclusions here, but I would assume that if the DEQ doesn't get what they want, they're going to revoke this permit anyway, right? I mean, they definitely have the power to revoke it. Is that correct? So probably,
Right.
I mean, that's probably going to happen without us, I would guess. I mean, I can only imagine, but that would be their next play, I would think. So we might be getting into someplace we don't need to. That's inevitable anyway. Just a thought.
All right. I think we're also under 701. Dr. Bagley, if you'll just review that real quick and
Yeah, I'm looking at
give
that.
me
Yeah, Madam Hearing Officer, I'm looking at that, and I guess it says that, you know, we shall affirm or modify such order, and it doesn't say, it does say or for the taking of other corrective action. So I don't think that prohibits us from revocation, but like I said, I'm willing to not make that amendment. I think we need to finish this, and you know, so something that we can say this is done. We don't need to go any, and you know, from what the testimony I heard, Mr. Good is not mining. He knows he needs to put a bond up to mine, and he's not at this point prepared to do that. So just some way to bring this to a closure, so we're not dealing with this again, this particular permit. But so, Madam Hearing Officer, I'm fine if we don't amend it to revoke the permit. I just wanted to throw that idea out there as a possible remedy.
Okay. All right. Thank you. Councilmember Fairservice, any comments?
No, well, one, I'm not in favor of doing something that the DEQ can or should do if the need arises.
Okay, so you're not in favor of doing an amendment, just
Correct. Yeah, I'm not in favor of revoking it.
Okay. All right. And Councilmember Flitner, any additional comments?
Nope.
All right. Well, we have a motion to approve the NOV and order as proposed by DEQ. Do we have an amended motion? Okay, not hearing any. Let's go ahead and take a roll call vote on that. Chair Lally.
I vote in favor of the order or NOV in order.
Okay. Councilmember Bagley.
I vote for the order, for the motion.
Member Fairservice.
I vote against it.
Councilmember Flitner.
Again.
And I am voting in favor of the order, so it is 3-2. Ryan, I think you're going to have to help me out. Does that mean we have
The order fails.
Yeah, this is Ryan, the 35-11-111E, or I think it's actually not E, it's D, says all matters shall be decided by a majority vote of those on the council. At this time, the council is comprised of 6 members, so there needed to be a 4. So it needed to have 4 voting yes. So all the 3 voted yes. That the motion does fail.
Okay, the motion failed, based upon a 3-2 vote. So with that, the rules of practice and procedure require this order to be out no later than 30 days after the hearing, and our hearing closed on December 6th, 2018. So, Ryan, that means the order must be furnished to the parties by January 5th. So if you could have an order drafted out to the council by December the 28th, 2017. And if council members could let me know as soon as possible if you have any concerns or changes, or you believe something needs to be amended in the order, let me or Mr. Ruby know. And then we are going to hold a teleconference on January 5th, 2018. Jim, do we have a time to vote on that order?
Whatever is convenient for you, Madam Chair, and the council as a whole. Anytime that day appears to be empty as far as Joe and I are concerned.
What day of the week is that, Jim?
I don't know. It is, yeah, I think it's a Friday, but I have to go back and look again. Hang on 1 second. It's Friday. It's a Friday. January 5th is a Friday.
All right, council members, would you be available for very briefly to vote on the order at, say, 11 o'clock in the morning?
Yes.
Hearing Officer Bomber, this is Dave Bagley. I will take a break from skiing to call in so that I can participate in this matter.
Okay, thank you. Rich, how about you?
I'm good for the 5th of January.
Tim? Okay, Tim, are you?
Yeah, I mean, if Miss Dr. Bagley can go through such a hardship to get there, I'm sure I can probably make it.
All right, so we will hold a teleconference on January 5th, 2018 at 11 o'clock to do a quick vote on the order. And with that, Chair Lally, I'll return the gavel to you.
Yes, thank you. Is there any other business? Seeing none, I will take a motion to adjourn.
So moved.
Second? Is there a second?
I'll second it.
It's been moved and second to adjourn this meeting. Thank you, everybody. And the meeting is adjourned.
You need to vote. I know it's all I, but.
Is there a motion? All those in favor?
Aye.
Aye.
Thank you. Sorry.
That's okay. Now we're
Thanks,
done.
everyone. Happy holidays.
Happy holidays.
Merry Christmas.
Thank you all.